Dr. Renata Alexander. She's a senior lecturer in the Faculty of Law at Monash University and a Victorian barrister. She teaches family law and clinical legal education at both undergraduate and postgraduate levels. And she is the author and the co-author of 3 books on family law, family violence and child abuse, as well as numerous book chapters and articles. Would you please welcome Renata? Thank you. Yeah.
Thank you. I was listening with interest to the Chief Justice, and I've just jotted down a few things. In response to some of the issues raised, and I'll just do it really in point form, some of the issues about the proposed parenting management hearings and what Professor Patrick Parkinson has seems to be promoting, and I've just written down some of the problems I see. One is that it's treating the symptoms rather than the cause, and we certainly have an overburdened family law system. I too welcome a review of the family law system, but I worry that it may get caught up in some of really peripheral issues. I also worry that the setting up of the PMH, or the parenting management hearings, will really just create another parallel pathway. And really, we have so many parallel pathways. We have 8 state and territory laws about family violence that coexist with the Family Law Act. We have 8 separate state and territory child welfare and child protection statutes that coexist with some of the child protection parts of the Family Law Act. And I think I would rather see a more unified system in those vital areas of family violence and child protection and child abuse than creating yet another platform or another pathway. I also have some concerns about the voluntariness of self-represented litigants applying to the PMHs. I did some research on voluntariness before mediation became compulsory in 2006, otherwise known as family dispute resolution. And I had some concerns there, and there's a lot of research from the Australian Institute of Family Studies in particular, that women in particular often will take up these voluntary pathways, but are under a lot of pressure to resolve. They can't access legal aid, they can't afford private representation, and they often agree to settlements, be they property or parenting arrangements, that don't have much longevity and that often is less than what they would be entitled to if they pursued the litigation pathway. So I have some concerns about that. Her Honour also talked about transparency, issues of disclosure, that in the new PMH there'd be a lawyer and 2 social scientists, psychologists, whatever other forms of experts. I certainly welcome the notion of introducing expertise into the family court and into the Federal Circuit Court, which involves social science, and I've been a proponent of that for some time. But I also worry about who those people would be, and if you like, the rather artificial distinction between good and bad social science, if you like. And the other thing I've written is about the Children's Cases program, which, from my experience, works well, but it's in a very small area of the family law system because it only operates in the family court. And according to the 2014-2015, or even probably the last one, the annual report of the Federal Circuit Court, the Federal Circuit Court hears 87% of family law cases. So that's the court that's really overburdened. In Melbourne, we have hearings now being set down in 2019. One judge I spoke to recently has 400 cases in his docket, and that's just, and I understand that's a similar case, particularly in Sydney and the registries on the eastern side of Australia. So all of those things, I think my general comment, and I've exceeded my 5 minutes, my general comment is I'm not certain that the new PMH proposal. Of course, as a pilot, it'll be subject to review and scrutiny and some sort of evaluation. But I'm not certain that's really such a good solution. I think it's really looking at the, as I said, the symptoms rather than what the underlying issues are. Thank you.